Welcome everyone to MyHR's 21 MyHR Live so far. In true Christmas spirit, it is raining up here in Auckland and it's turned into a very gloomy December day. We are on the countdown to Christmas, I'm sure you are as well. And so the topic today is a review of the law changes that came through this year, a quick recap of some of those topics in case you missed them, and then a look ahead to what we can expect in 2020 in terms of law changes. So as first, always, we do some housekeeping. Feel free to ask questions as we go through. We'll be collating them and answering them at the end, and if you have questions afterwards or there's anything we didn't get to, you can always contact us at info@myhr.co.nz or give us a call on 0800 69 4769. This video will be available on our YouTube channel afterwards, so if you miss anything, you want to rewatch it, share it around, or if you have any technical difficulties, you can access the video later. Of course, this means if you do ask questions, they will be on the video and people will be able to see them afterwards. So please make sure you don't use any identifying details if you do have questions, and we'll make sure to be sensible about what we do and don't include from your question. So the context for 2019, of course, was that this was Labour's much touted year of delivery in terms of getting a lot of their changes and their policies through. We certainly saw a lot of change in the labour law and employment relations space. Some of this was resetting some of the rules and guidelines around things like breaks back to, I guess, what you would consider the typical labour settings around prescribing breaks and that kind of thing. Some of the content was new though. It's the first time we've ever had domestic violence leave in New Zealand before, and we're certainly one of the first countries in the world to do it. So there was a mix of stuff that could have been expected with a change of government anyway, and some stuff that we haven't seen before, and so has been a bit of negotiation around figuring out how it works. So this is going to feel like a bit of a laundry list of changes. I'll do my best to move through them quickly. For most of the points that I'm going to cover off today, we do have resources up on the myhr.co.nz website. We've also done, as you are aware if you're a regular watcher, we've done a lot of MyHR Lives on these topics as well. So there's plenty of content around if you want to dive into something deeper. And again, you can always contact us if you have any questions and we can point you in the right direction. So we will crack on. The first thing to be mindful of is that Labour made a commitment to increasing the number of labour inspectors around. That funding came through and they're on track to increase the total number of labour inspectors around the country from 60 to 110 by the end of 2020. So that's nearly a doubling in the amount of resource they have nationwide to look at breaches of the Employment Relations Act, to follow up on employers who aren't doing the right thing by their people, and to generally kind of enforce and draw attention to compliance with all of the employment entitlements that your people are entitled to. So that increase in labour inspectors is going ahead. One of the changes that came through, which was technically 2018, but I thought we'd talk about it today because it is worth mentioning, is that in December of 2018, reinstatement to your job became a primary remedy for the courts to use when an employee has won a personal grievance claim. So what that means is if an employee was to win an unfair dismissal claim, if requested by the employee and if the judge or the authority member thought it was reasonable and kind of practical to reinstate the employee to their job, that would be the primary remedy of the Employment Relations Authority. Reinstatement means the employee gets their job back. So we've seen a couple of cases where that's been applied. It hasn't been the big rush that we were expecting, but it is something that we're talking about with our clients and asking them to be mindful of if they are facing an unfair dismissal claim. Next was the minimum wage, which is something that goes up every year, so not necessarily a surprise for 2019. And the minimum wage increased on 1 April 2019 to $17.70 an hour. That had flow-on effects, of course, for the starting out rate and the training rates as well. And yeah, next year we're looking at increasing the minimum wage further, and I'll talk about that a little bit more when I talk about what we can expect that figure might be. But we're expecting a pretty hefty increase to the minimum wage again. So good, something to keep an eye out for. So domestic violence was the other thing that came in this year, and that was 1 April 2019. Domestic violence leave we've talked about extensively with our clients, and we did a really thorough MyHR Live video on as well. So I'll go through the highlights just to tick it off. Paid leave of up to 10 days per year after 6 months service with the employer. That 10 days leave will reset to 10 days every 12 months, but it doesn't accumulate from year to year like annual leave does. So you will only ever have access to 10 paid days of domestic violence leave per year. can be for domestic violence experienced at any point in a person's life. It doesn't have to be violence or an incident experienced while they were employed with you. Employees who are experiencing domestic violence also have a right to request flexible working arrangements, and employees experiencing domestic violence are now a protected class for discrimination, like sexual orientation or religion or union membership. They're a protected class of employee. We talked a lot about the appropriate way to manage this, and we forecast at the time when this came into effect that we didn't expect there would be a massive uptake. It was really unlikely based on the advice from the domestic violence specialists in New Zealand, as well as from the experience of other countries who have similar leave entitlements, that pulling a DV day was unlikely to happen, like employees pull a sick day sometimes. And certainly our experience across our 750 clients now has borne that out. We've only had one instance of an employee potentially claiming for domestic violence leave when they weren't entitled to it, and we've had a couple of handfuls of examples of people asking for it when they are entitled. So there hasn't been a big rush on it. The fear-mongering around what this might mean for absences has proven so far not to be justified, and it will be really interesting to see the reports that come out next year after it's been around for a year, to see what impact it's had on people's ability to retain their employment, but also of course do what's right for them and their families in managing some of those situations. So we'll keep an eye out for that in 2020. One of the other major changes was around breaks. So in May of this year, breaks are prescribed again. The national government changed the settings so that you could agree with your employees to pay them in lieu of taking a break, and that they could opt out or receive time off in lieu or so on. So you had a lot more flexibility about how you were managing those breaks. And true to form, the Labour government has made a change so that rest breaks and meal breaks and rest breaks are now prescribed and must be given to employees within certain shift lengths. So I've got a pretty table that breaks it all down. I won't go through the whole thing, but if you are an employee who works a shift or works for a period of time of 0 to 2 hours, you have no entitlement to a break. That's pretty clear. If you work 2 to 4 hours, you get one paid 10-minute rest break. If you work 4 to 6 hours, you get one paid 10-minute rest break plus one unpaid 30-minute meal break. If you work 6 to 8 hours, you're entitled to 2 paid 10-minute rest breaks and one unpaid 30-minute meal break. And for every 2 hours that is added onto the length of your shift, the number of breaks you're entitled to increases. So you can't opt out of giving those breaks to your employees. If your employees are saying they're too busy to take them, unfortunately that's not good enough. You have to arrange your working day and your work requirements so that your employees can take those breaks. If you need to agree on timing to do them, that's fine. You can mutually agree on the timing of the breaks, but they must be taken during the day. There's plenty of research showing that breaks are really important to staying healthy and safe at work, which is true even for those of us who work desk jobs and don't have necessarily physically tiring jobs, but mental fatigue is a risk that needs to be managed as well. So breaks are really important for that. What's worth noting is that there are a small number of industries who are exempt from that law. So services that are that fall into things like gas provision, so petrol stations, nursing, really important kind of health work. Some of those roles will be exempt from the breaks piece, because when you're in the middle of surgery and the clock goes and you're meant to take your 10-minute break, that's not going to play out. But for most businesses across the country, breaks are now prescribed. So give us a call if you have questions about that. We're very happy to talk and help you figure out what's going to work for your business. Trial periods was also one of the big changes that came through this year. So in May, the law changed to mean that employees with 20 employees or more can no longer use the trial period legislation. If you have 19 employees or under, that's totally fine. You can carry on using the trial period as you have done previously. But the government decided in negotiation with New Zealand First that if you have 20 employees or more, basically they reckon you're big enough to deal with any performance issues on your own, and so they've removed the trial period because, of course, one of the features of the trial period is that it removes an employee's right to take a personal grievance. So Labour in New Zealand First said that might be okay for small businesses where they don't have a lot of resources and you're having If you're a business of 8 people and one of your new hires is a dickhead, then that's suddenly 12% of your workforce is a dickhead, and so leaving that there for you to use was a decision they made. But for businesses of 20 and over, no trial period, it's a probation period change. What's caught some of our clients up is counting who falls into that 19 employees or fewer bucket. So that includes fixed term employees, it includes permanent, it includes casual employees. So if you are a business which has a large casual workforce and a small permanent workforce, being mindful about how you track and count those employees will affect which bucket you fall into and whether you can or can't use the trial period. We've helped a number of clients since May with probation period terminations. They're in some ways much more flexible than a trial period because you can use them for employees who've worked with you before, for example. The employee doesn't have to have signed their agreement before they start. We advise it as good practice anyway, but it's not fatal to a probation period like it is for a trial period. And they can be extended with the consent of the employee, unlike trial periods which were totally capped at 90 days. So there are some benefits to using probation periods. If you do have any questions about how those work or how they're different, again, get in touch. We've got a lot of resources available on the differences between them and what's important to get right. So do get in touch if you have any questions. We're happy to help. There was a second tranche of changes to union rights and access that came out this year, the first being late last year. So the set of changes that came out this year were things like restoring the duty to conclude bargaining for single employer collective agreements, restoring the 30-day rule, so new employees are covered by the terms of the collective which would apply. Pay rates need to be included in collective agreements, and you must be giving all new employees an active choice form when they start so that they can choose whether to opt in or opt out of the union. So if you deal with unions, you will know that they are really concerned with protecting the rights of the employees who are members of the union, and they are quite active and very communicative with you as the employer to make sure that you are respecting what's been agreed with them. If you are dealing with a union, we often recommend that you do get some professional advice to make sure that you're negotiating fairly and aren't at an unnecessary disadvantage. But yeah, there was a bunch of stuff that came out for unions in terms of making them more accessible and making them more prominent in the view of employees at work. So this set of changes was a further step towards that. We've had vulnerable workers for a while now, but in May this year there were another couple of tweaks to that law. Specified vulnerable industries now had the right to change employers if their job is restructured out regardless of the size of their employer. I believe there used to be a size limit. And there is also a longer notice period given to employees if they are choosing whether to go to the new employer who's got the contract. Vulnerable workers are those who provide cleaning, food catering or laundry services. So it's not every employee who maybe is from a low socioeconomic background. It's very much about the type of work that they're doing and the industry that they're in. So if you're not sure if that's covered, if your workers are vulnerable, get in touch and we can help you figure that out. A small note, because this was a straightforward change in principle but not necessarily in practice, was payday filing came in this year. So from 1 April, employers were required to file payroll information every payday, and if you're doing it electronically, that was within 2 working days of the pay being processed. So if you were running, for example, a weekly payroll for your waged or your trade staff, and you're running a monthly payroll for your salaried or your office staff, you would need to be filing 4 times a month for the weekly people, or sometimes 5 times a month if there's 5 pays, and once a month for your salaried people. So be mindful if that's something that came into effect and that would affect you this year. So that's a really quick high-speed run through the changes that took place this year. What I would like to do very briefly is forecast and talk about the 4 main changes that we can expect next year. Some of these are still TBC, some of them are concrete, and we'll talk more about them, of course, when the time gets a bit closer to them being implemented, but just making sure that they're on your radar so you know what to expect in what I'm sure is otherwise a busy year in 2020. So the government has already confirmed that the minimum wage will increase to $20 per hour in April 2021. So not next year, but the year after, the minimum wage will be $20 per hour. We're currently at $17.70 an hour, So if we split the difference and expect that they will make close half of the gap between $17.70 an hour and $20 an hour in 2021, next year's minimum wage would be $18.85, so an increase of $1.15 on the current minimum wage. This tends to get announced in the new year, so we will communicate with our employers and our clients for whom it affects closer to the time, but expect a reasonably chunky increase next year as well. So that's change one. Change two is that the Employment Relations Triangular Employment Amendment Bill has been given royal assent and will come into effect in June of 2020. So the point of the Triangular Employment Amendment Bill is to address some structural limitations on employees who are employed by company A but do work for company B. So that would typically be a labour hire company or a temping agency, any of those types of organisations where they pay the employee directly, but the employee for most of their week or most of their month does work for a different business at that business's site. So what will happen is that employees who fall into that arrangement where their employer is over here but they're doing work for businesses over here, they will be able to be covered by a collective agreement that would apply to them if they were an employee of this business over here, and they will also be able to take a personal grievance against company B, which is engaging them but isn't their employer. So a typical example would be if you're an office administrator and you're a temp and you're working for agency ABC over here and you go into work for company XYZ as an office admin, if something happens where you are disadvantaged, if you experience discrimination or harassment, if there is anything which causes you concern, you will have the right to take a personal grievance against company XYZ, even though your employer on paper and in payroll is company ABC. So we're planning on doing quite a bit of work around this at the start of next year because it will affect, I would expect, a number of our clients who do use labour hire or contract or temp staff, but just be aware that that is changing next year. So have that on your radar in terms of what to think about for 2020. The fourth thing that is in progress at the moment, and it's probably a bit premature of me to say that it will happen in 2020, is that the government is consulting on fair pay agreements. So fair pay agreements would be industry standard agreements which cover all hospitality businesses, for example. So from the government website, quote, fair pay agreements would create a new mechanism for collective bargaining to set binding minimum terms at a sector or occupational level. These agreements would be a set of occupation and sector-specific minimum employment standards, such as wages, redundancy, or overtime. They will be agreed through bargaining between affected workers and employers and will then become legal requirements in that sector. So for people who've worked in Australia, it's similar to their kind of award system. For those of us who were practicing or practitioners in the 70s and 80s, it's a model that is not dissimilar to those circumstances. The consultation period closed at the end of November, so we're expecting the government to come out with some recommendations around one, the structure of them, two, the mechanisms for how they would be implemented, and then a time frame for those coming into effect. So might not happen in 2020. It's taken a long time for the Fair Pay Working Group to be set up and then have their recommendations given to the government, but this is something that is churning away in the background and was certainly part of Labor's commitment to their union kind of base. So keep an eye out for these, but of course there is an election next year, so if the government changes, we might see these put on ice or parked for the moment. The last change for next year to keep an eye out is for the Equal Pay Amendment Bill, which is currently at its second reading, so it's not law yet, it's just going through the process. The purpose of the Equal Pay Amendment Bill is to improve the process for raising and progressing claims for pay equality, and to help eliminate and prevent discrimination on the basis of sex in remuneration and employment for work done within female-dominated jobs. So you may remember there was a lot of news coverage earlier this year and last year around care workers getting their claim for pay discrimination kind of accepted and approved, and then an industry-wide increase in pay rates. So this is a reaction to that set of circumstances and those claims raised by those workers. So this won't apply to everyone. In industries where it's not considered a female-dominated job, I wouldn't expect this would have much effect, but it's certainly the government making an attempt to legislate mechanisms for people who are in work which has historically been dominated by women and therefore historically underpaid to raise claims and get them addressed. So that's the point of that piece of legislation. And that's it. It's been a really long 2019, and part of the length of that has been the number of changes in employment relations. There will be more to come next year, and so we do expect to be having ongoing conversations about the changes in the employment law landscape, but that's everything that we is on the radar at the moment. Do we have any questions come through from anyone? No one at the moment? Easy. Everyone's bludgeoned into submission in a busy December. Thank you so much for watching today. We appreciate your attention and hope that was useful. Thanks also for your support and for your attendance at these videos, at these sessions throughout the year. We get a lot of questions come through from them afterwards, and there's a lot of uptake in terms of sharing and visibility, which is fantastic. So thanks again. I hope you have a wonderful, safe, restful, sunny holiday season lined up, and we will see you again next year for more of the MyHR Lives. Thanks again.